Greetings and welcome to this webinar, After We're Gone, Protecting Those with Special Needs Through Estate Planning. Whether you're taking part live or listening to the recording later, we're very glad that you're here. My name is Lyle Miller, and for the past several years, I've had the pleasure of volunteering on the board of Anabaptist Disabilities Network, and I'm currently serving as the secretary on the board. ADN is an organization that connects and supports people with disabilities, their families, and their faith communities, seeking to create a culture of belonging for everybody. And we do this through providing resources to congregations, online and print newsletters, congregational accessibility assessments, barrier-free grants for churches, and so much more. And it's been great to be part of this wonderful ministry for a number of years. In my employment, I serve as a stewardship consultant for Everence, and in that context, I'm often talking and teaching about general estate planning and the importance of that for everyone as an act of stewardship, no matter your age or family situation. But for those of us with a family member with a disability, however, there is a significant added consideration. How do we ensure that our loved one, who's often someone for whom we've played a significant role in helping them to navigate life, how do we ensure that that loved one will be positioned to succeed when we are not around? And that may involve considerations about where they will live. It could be about who will assist them or care for their needs. And perhaps especially important and connecting with our content this evening, depending on the types of state or other benefits that they receive, how do we ensure that an inheritance won't jeopardize their ability to receive assistance? We're fortunate tonight to be joined by Jennifer Lyle, who is an expert on this topic. Jennifer is an attorney with the law firm of Krugliak, Wilkins, Griffiths, and Doherty, based in Northeast Ohio. She specializes in a number of areas, including special needs planning. She received her undergraduate degree in secondary English education, graduating with honors from Kent State University, and she completed her law degree from the University of Akron School of Law, graduating with honors there as well. Jennifer is a certified specialist in estate planning, trusts, and probate law, along with being a certified elder law attorney. And she was voted one of the best lawyers in America by Ohio Super Lawyers. For our consideration, it's particularly worth noting that Jennifer is a current member and past board president of the Special Needs Alliance, which is a national alliance of attorneys who specialize in planning for those with disabilities. Jennifer is a frequent speaker to community groups on topics such as estate planning, special needs planning, and elder law, and is a lecturer to attorneys, accountants, and financial advisors through various professional organizations, as well as local, state, and national bar associations. And she is also a contributing author to articles published in the Probate Law Journal of Ohio and The Voice. So welcome, Jennifer. Thank you for being here.
Thank you very much, Lyle. It's just an honor to join all of you, and I've so appreciated Lyle's work in the past and his passion, and so it's really quite a treat to be with you all. I will make just a mention, it's a little bit of a segue here as far as that comment about the Special Needs Alliance. There will be a slide at the end that mentions the Alliance. There are a couple of publications, actually quite a few publications on that website that you might find useful. There's a handbook for trustees that I often give to clients who come to meet with me about special needs planning, and one about having an adult child with disabilities. So I think it's just a great resource to go poke around and find materials that might interest you. So let's launch into our program. And again, you will have all of these slides. But I'd like to start out with some myths, because most folks come in with some ideas in their mind that are maybe not quite accurate in their fullest degree. So the first myth is the most common. I need to disinherit my child or my beneficiary who has particular special needs and give that to somebody else to hold on to. And so two daughters, one has particular needs, give it all to the daughter that doesn't, and they'll watch over that and so forth. We'll talk about some reasons why that's not such a good idea. But that actually ties to myth number 2 as well, that if a beneficiary receives an inheritance, they automatically lose all of their benefits. They have to spend that inheritance as quickly as possible in order to reapply and reinstitute those benefits. So if you allocate assets to or an inheritance to somebody else directly on behalf of another individual, we just don't know what's going to happen. And an example of that would be if you allocated everything to one child for another and that child predeceased, or they went through some type of a creditor issue, they got sued, or they had a divorce, or you could name a number of things that could happen. What was intended to be managed for the benefit of somebody else now is at risk and is may not end up in the hands that it was meant to go to. A third myth is more and more an issue because more people are becoming aware of stable or able accounts, as they're called nationally. And I'll be talking quite a bit about able accounts. They're a very good tool, but you have to be careful, and we'll see some slides about that, that we don't think that that you don't get lulled into the notion that an able account will solve all planning problems. It's limited in its abilities, and we'll see those limits shortly. Myth number 4 kind of ties together with myth number 5, and that is who's going to be in charge of something? Who's going to manage or take care of something? We think of, just in terms of being human beings and being stewards of what the Lord gives us to handle and so forth. Well, who's going to be the steward when you pass away for somebody that you love that needs that, oversight? Well, it doesn't happen automatically. And those people don't grow on trees. You have to make those decisions and should make those decisions ahead of time while you're able to. Courts can step in and they can appoint parties to do that kind of work. But really, if you can do that ahead of time, you're in control of that. A court may look at the picture differently than you would. Myth number 6. Other family members or other friends who may want to set something aside for a beneficiary with special needs, they all have to do their own separate trust, their own separate planning to be able to make that happen. No, that isn't quite true. I have a number of situations where we have a special needs child and grandparents also want to include that grandchild in their plan in some way, maybe as a fractional interest of some account or of some life insurance policy or some asset. Well, there are ways to piggyback onto the planning of another person, like their child, who sets up a plan for the grandchild. And so using a trust in a way that allows multiple donors can be very efficient from the perspective of legal fees and other just administrative aspects. And then final slide about myths, just kind of rounding all of that out. Myth number 7 is the idea that if someone receives benefits, they lose all of those benefits if they get an inheritance or if they get monies from some source. We'll see in a moment, actually on the next slide, that is not true, and it's important to figure out which benefits are affected and which aren't. Myth number 8, you have to treat every beneficiary equally. That idea of every child being treated exactly the same, getting exactly the same amount. It's okay to do that, but it's not mandatory. There's no legal obligation to treat every child exactly the same way with exactly the same amount of inheritance. It is worth really thinking about that when you have a special needs beneficiary, because we know that the needs are going to be different and the opportunities are going to be different. And so maybe it means a higher percentage is allocated toward that person's special needs trust. Maybe it's a lesser portion for some other reason. So it's an important myth to dispel and to think about when you're doing planning. Myth number 9, I kind of throw in here because it ties into some of the other slides that we'll be talking about shortly. And this idea of, well, I don't need to do anything special with my other documents. If I do a special needs trust, everything else can be standard, run of the mill, get things off the internet or whatever your, path is. Powers of attorney are another critical piece in planning. And I would encourage you to get one-on-one advice from an attorney if you're going to do a power of attorney that relates to finances. Those are called powers of attorney for property or durable general power of attorney. They go by different names. But the idea is that a power of attorney that has to do with finances can be customized in a way that is beneficial down the road. And again, we'll be touching on that more in a few minutes. And then finally, myth number 10, a person with special needs can never do their own estate planning. Well, some cannot. We understand that sometimes the limitations are just too great. Cognitively, there's not a level of competency that would work for that. But there are many individuals who do have the capacity to engage in and take care of at least basic estate planning documents. The power of attorney that I mentioned, a healthcare power of attorney, maybe even a simple will. And disabilities, of course, can take all kinds of forms. They aren't always cognitive. They may be physical only. And of course, that's not a reason that you can't do your own estate planning. Having estate planning documents for someone, an adult who is able to do them, can really alleviate the pressure and kind of obstacles of having to go through guardianship or conservatorship through probate courts or other local courts. So don't rule it out. It's definitely something that many individuals can do and turns out to be beneficial. Now, when we look at the basic benefit programs, here is where we get into this idea of what benefits is somebody receiving and how does that play into their lives and how does that play into your planning? These 4 benefit programs are kind of the core 4. There are others. There are Section 8 housing benefits. There are a variety of other things. And at a state and local level, there may be even additional benefits that could be tapped into. But here you see that the top 2, Social Security Disability Insurance, otherwise known as SSDI, and Medicare, are not needs-based. And I use that terminology very carefully. That means that those 2 benefits are not affected by the financial changes, perhaps the receipt of an inheritance that may come into the hands of somebody that has a disability. On the other hand, supplemental security income, known as SSI, and Medicaid are needs-based. They care very much what the assets are and what changes occur in someone's assets or income. And if you exceed various thresholds, you will lose those benefits. To complicate things a little bit with this, well, let me mention the supplemental security income and SSDI, Social Security Disability Insurance. While they have similar kind of terms there, technically SSI is not Social Security in the true sense. Social Security, which we'll see in a few minutes, has various components to it, one of which being that somebody paid into it, and so it's an insurance benefit that comes back out. But even though it's not Social Security in the true sense, it's administered by the Social Security Administration. So we tend to kind of lump it together, but they are funded differently through the government, and they operate differently in terms of eligibility and how they're affected by other things. Now, I want to make a particular note about all of this, to remember that it is very important to figure out which benefits an individual is eligible for, and to not think that that's a one-time answer. This can change dramatically over time. I have a number of individuals, a number of clients who are what we might call quadruple eligibles. They're eligible for all 4 of those benefits at a given time. Let me give you a quick example of how that can start and how it can evolve. If we have a situation in a family where there is a child born with a disability, and they grow up, and so they had their disability before they were age 22, which is a critical age for Social Security purposes. They may, once they reach adulthood, become then eligible for SSI, a monthly benefit, a financial benefit, monthly check, and Medicaid. And those are both needs-based benefits, but because they, let's say, are not able to work, they aren't paying into the system. And so these are programs that are designed for them. They don't have to have worked. They don't have to have paid in. Now, as life goes on, their parent, let's say one or both parents, retires or dies or becomes eligible for Social Security disability insurance themselves because they have a disability and they paid into Social Security during their working years. The child, who is now an adult, can, when the parent's parent benefit is triggered, can get a derivative Social Security benefit as what's called a DAC, a disabled adult child. And what happens in that situation is that the Social Security Administration looks to see, okay, you're getting SSI of, let's just say, a round number of $1,000 a month. You could get now, because your parent has retired or maybe they've passed away, and based on their work record, the parent's work record, you could get $1,200 a month. They will take away the SSI benefit and now give them fully an SSDI benefit. And you might say, well, is it really worth it for an extra $200 a month? Well, yes, it would be. And even if it was only $1 extra a month, it would still be worth it. Because after you are on SSDI for 2 years or 24 months, then you become automatically eligible for Medicare. And Medicare becomes the first payor for medical benefits. And more providers accept Medicare than generally accept Medicaid. So it generally opens up much broader provider network. Pausing there for just a moment. Another example would be, let's say the same situation occurs, but at some point that adult disabled child becomes eligible for SSDI, and let's say that amount is only $500 a month. What does Social Security do? They say, okay, we will give you your $500 of SSDI. We'll also give you your $500 of SSI. We won't give you less than what you would have otherwise gotten under SSI. So you'll become eligible for 2 deposits, not exceeding, in that case, the SSI amount, but beginning that SSDI. Again, for that purpose that ultimately Medicare gets tacked on, and that's a benefit. In addition, that SSDI is not as sensitive. It isn't as, in case you were over-resourced in a particular month, you wouldn't lose that piece of your benefit. And so there can be, advantages for pursuing those benefits. And typically, not always, but typically, Social Security will be aware of these things. And they will instigate it. If they know a parent has now claimed retirement, they will ask, do you have a child with a disability typically, and those sorts of things. I have had a few cases where apparently those DAC children, disabled adult children, fell through the cracks, and Social Security recognized that after a number of years and made very significant back payments to the tune of 6 figures. I had 3 young men that happened to, and we scrambled around and got special needs trust set up for them, and they got that benefit, and were able to use those funds in wonderful ways in their lives. But that's an example. Now, I will say that the Medicare Medicaid piece, the medical side of things, normally you will, once you become eligible for Medicare, if you do eventually, the Medicaid will still continue. It's rare to lose the Medicaid unless you intentionally decide to go off of Medicaid. And the reason I say that is that Medicare covers a lot, but it doesn't cover everything. There may be copays, there may be deductibles, there may be various things that Medicare doesn't cover, and Medicaid will slide in and do that additional coverage. So it'll be the secondary payer. Some individuals, in a variety of cases, and I've helped families navigate this and decide on this, will instead decide to privately pay for a Medicare supplement plan and just take away the Medicaid, perhaps because of, limits on providers and things of that nature. All right, so thanks for hanging through on that discussion. It can get a little deep, but this is one of the big threshold issues that we talk about when I first meet with the client family to figure out the picture and how things are going to play together. The next slide here goes into more detail about the differences between SSI and SSDI. And this is a great slide to go back to when you get the materials, just to kind of see, okay, what are the little nuanced differences between them? I've pointed out a few. I'm not going to go through every one here. You know, that'll be more for your reading down the road. But the one I want to make a little note on is the second one, that work requirements line. And you'll see under SSDI, it says must have paid into the Social Security system. Just note, and this is what I was referring to a moment ago, that it doesn't have to be you as the taxpayer necessarily. It can be a parent of a child who had their disability prior to age 22. So it doesn't have to be the person themselves that paid into the system. Now, if the disability occurred after 22, which happens in a variety of situations. You know, many times those who end up having challenges with mental illness, that doesn't show itself, it doesn't have its onset until later. Sometimes other disabilities that result in an accident or medical situation, you know, just either don't manifest themselves or don't have an onset until later. And in those cases, you don't qualify as a DAC. You may be on SSI for the remainder of the time, remainder of your life. All right, now another concept that ties into SSI specifically. So this is the supplemental security income, the one that is needs-based, and this is just monies. This is just an income stream. The idea that ties to that is in-kind support and maintenance. That's a mouthful. We call it for short ISM. And ISM has lots of nuances to it, and we will just barely scratch the surface here today. But one of the things that I wanted to do in this program, because many of you have some familiarity with these concepts, is point out some changes that you might not have known about, or that other professionals you work with may not be aware of if they're not kind of immersed in this day to day. And the big change, really big change that happened just this past year in September, was that in-kind support and maintenance dropped from its list food. So there is a list, and this is in the Social Security, what's called the POMS, the Program Operations Manual system, that it has a list of the items that are considered shelter costs. And shelter costs are the expenses that SSI views that they should pay, or that the Social Security Administration should pay. And they are things that you would think normally about. So rent, or a mortgage, or basic utilities, gas, electric, those sorts of things. And food was on that list for many, many years. Similarly, many years ago, clothes were on the list, but that got dropped off the list. And with food and clothing off the list, what that does is it means that there's no pressure when we're looking at what can other people pay for the beneficiary without causing that benefit to be reduced. Because if a shelter cost is paid by somebody else, whether it's a parent, a sibling, a trust, if those costs are paid, like let's say a rent payment is made for a special needs beneficiary. If it's paid by somebody else and they're relying on SSI, their SSI benefit will ultimately be reduced. Typically, it's reduced by a third. Usually that's the maximum that it would be reduced. But that can be a pretty big hit if that's their primary resource. So just wanted to let you know about that. And I could talk for another hour on that, but I'll move on and get to some more materials here. So there are different types of special needs trusts. And the big broad categories are broken into two areas: self-settled trusts, or we could also call them first party trusts. So a trust that's established in some manner by the beneficiary. Not necessarily, they may not have created it for themselves exactly. It might have been their agent under power of attorney. It might have been their parent or a grandparent, certain qualified individuals, but it was established on their behalf or by them. The other kind is a third party settled trust. And so this would be a trust that is established and funded by a different person, not the special needs individual. And so you'll see on this slide a couple of different types under each of these categories. And I think this is a useful little slide because you will hear some of this terminology, and we'll be talking about it here in more detail. But under self-settled trust, the most common one we call a D4A trust. Why do we call it that? Because those are the last letters of that code section, that federal law, the United States Code. Another type is a qualified income trust, and that's also under that code section. And a third kind is a pooled special needs trust. All of those are under the 1396P D4A, D4B, D4C. They're all in a specific law. Then there are the third party trusts, and these may fall under certain statutes in certain states. As a general concept, they're not under a federal statute, they're under the federal common law. So that's common law is made up of cases. In various states, my own, for example, in Ohio, we have codified this. And so we actually have a law on the books about third-party trust, which is helpful. Then we're also going to talk about sole benefit trust. That's another type of a trust that can be created by a third party for a special reason. So let's dive into these in more detail. A D4A trust. So this is just the statute section itself. You'll see that it says 4A. So it's that specific code section. What I want to point out about this language is that it has to be set up for somebody under 65. You're not eligible to create this or have this created for an individual if they have reached the age of 65 or over. It can only be created by that special needs beneficiary himself or herself, a parent, a grandparent, a legal guardian, or a court. This can create some problems. Sometimes none of these parties are easily able to do this, or maybe some have died and so forth, but those are the threshold rules for creating a D4A trust. Now we have some additional rules relating to this, or some additional guidance. One is with a self-settled special needs trust, it should only hold monies that belong to that special needs person. Let me give you a few examples. One would be if the parents didn't do any planning and lo and behold, a special needs child gets an inheritance. They get part of a retirement account or a life insurance policy, and they're going to lose benefits if they just take it. Well, you can turn around and put that into a D4A trust, for example, and then it can be used through the rest of their lifetime. But it doesn't, their benefits then remain intact or can be reinstated if they've temporarily lost them. If a special needs individual gets money from some other source, maybe they're in a car accident and maybe they have some injuries and they get some kind of a settlement. Well, that's another type of monies that it belongs to them. It's theirs. They were the ones that were in the accident. But if you put it into a D4A trust, it doesn't cause them to lose their benefits. One more type that would be somewhat common, and that is if a child is entitled to child support. Maybe parents are getting a divorce and there's a child support obligation. That child support belongs to the child. It is their money. But we want to stretch all of those dollars as far as we can. And so if those are assigned to a D4A trust or are paid to a D4A trust, then the benefits can continue, the Medicaid support, et cetera, and the child support can be supplemental to all of that. But we don't ever want to commingle those monies with a third-party trust or with third-party monies. Because if we do that, then we have created a problem. What's the problem? It's the next point. Payback requirement. A first-party self-settled trust, the biggest difference between that and a third-party trust is that the first-party trust must have a payback section. It must say that when that beneficiary passes away, anything still remaining, if anything, is subject to being reimbursed to the state or states that have provided Medicaid benefits. It's not reimbursement to the federal government for SSI. It's only reimbursement for medical benefits paid through a Medicaid program. A third-party trust does not have that requirement. And it's sad to me to see this, but I've seen practitioners who didn't understand these rules create third-party trusts that had a payback section in it. And that's wrong, and that's not appropriate. I also see caseworkers who think that all special needs trusts across the board have to have payback requirements, and that's not true either. So this is where, becoming knowledgeable is helpful. All right. Third-party special needs trusts now are different, and generally, this is generally true across the board, these trusts are irrevocable, meaning you can't go back and change them, although of course we put in little ways that things can be tweaked here and there, and we usually have a special amendment power to keep them compliant with state and federal laws and things of that nature. But a difference with a third-party special needs trust is that sometimes they will be revocable because they are designed to be funded when, for example, a parent passes away. So I may create a third-party special needs trust, and it might be named as the beneficiary under the parent's will or under their revocable trust or on their life insurance or retirement account. It may name that trust as the beneficiary instead of the special needs person directly, but it may not hold anything for a long time. And we can structure those to be revocable until the parents pass away, until they're no longer alive to make changes to it. So it may be revocable if designed to receive future inheritance, for example. Otherwise, if it's going to be funded right away, or when it does get funded, it does become irrevocable. And that's one of the things that caseworkers are looking for. Does this trust ultimately meet the criteria? One of those criteria being that it is irrevocable once it's funded. In all of these special needs trusts, not just third-party trusts, but we'll point it out here, distributions, whether they're distributions of income or principal, which is meaningful to those financial advisors out there, can be used for the benefit of the beneficiary and only the beneficiary. So we consider them sole benefit trusts in that regard, and only at the trustee's discretion. They must be wholly, WHOLLY, wholly discretionary. In fact, in Ohio, our statute refers to these being wholly discretionary trusts. What that means is there is no mandatory standard, no mandatory distributions that must occur. It's completely at the trustee's discretion. And that way, nobody, including Social Security and Medicaid, can force the trustee to make distributions for various expenditures. Generally, you're going to see terms like sole, absolute, uncontrolled discretion. That's the kind of language you're going to see. If you see language that says, this shall be distributed for the health, education, maintenance, and support of the beneficiary, that is called a HEMS standard, health, education, maintenance, and support. That's an ascertainable standard, and that creates big problems for special needs trusts. So we don't want to see that language in there. And I've taken many trusts to the court to have them modified to remove or revise that language to avoid a problem. There are some new and exciting developments in the realm of retirement accounts. And I'm going to move along here a little more quickly, but I mentioned to Lyle earlier, I have lots of resources that I've gone back to on these sorts of things. One is it's a little bit outdated now, but it's an year-old 86-page program on just this one issue. I'm just giving you a little teeny tiny taste of it here today. But I want to let you know about these changes. So in 2019, of course, the Secure Act passed, and then in 2022, Secure 2.0 came along. And I will give a lot of credit to the Special Needs Alliance. The advocacy during that period, that intervening period, which of course was the pandemic and so forth, was very beneficial. We actively wrote to the legislators, and they listened to us, and they revised the way that a retirement account is treated when it is designated to or for the benefit of a person with disabilities. Generally, trusts that cover this, such as the ones I've been talking about, are considered ambits, applicable multi-beneficiary trusts. Not going to get into all those details here today. Maybe we'll do a part 2 sometime on this. But the Secure Act 2.0 then took it all a step further. So what are those new developments? What are some takeaways from that? First of all, distributions from an inherited IRA can be stretched over the lifetime of an eligible designated beneficiary. And that specific time, their type of beneficiary, there are various types, but the one I'm talking about here is somebody who is disabled or qualifies as chronically ill, and there's a definition for all of that. And if that is designated to a properly drafted trust, then this is very different than how adult non-disabled beneficiaries or children are treated. What happens here is, instead of being confined or required to take the distributions over a 10-year period, the third-party special needs trust for a disabled child can stretch those payments over that child's lifetime. That can be very impactful from a tax perspective, particularly if the retirement account is sizable. Now, there are layers here, and there may be some tax consequences because this is going to flow through a trust, and whether it gets distributed out then for the needs of the beneficiary in the given year or accumulates in the trust, that's going to depend on what the trustee decides and what the beneficiary's needs are. And the trust may have to pay income taxes if the monies that are pulled out of the IRA in a given year are not used for the beneficiary. But we weigh that against the benefits that are being preserved and utilized. And you can strategically work with that. You can figure out, okay, what would be best to pull out this year to use for various expenditures. So being able to make those stretches is very helpful. And another takeaway from this, which hopefully is good news to the ADN and many other organizations, is that the benefits, the remainder of beneficiaries can be specially set up. So the next slide, when the distribution is made from an IRA, for example, to a trust for a special needs beneficiary, third-party trust, that allows the trustee to manage it for the beneficiary. So not only are we protecting their benefits, we're also putting somebody in charge who can hopefully either on their own abilities or using counselors and advisors, continue to invest those monies in a prudent way and have those funds grow. And again, as I mentioned earlier, the underlying benefits of the individual are not affected. The next slide is where I want to really point out an important point, and that is under the second item, IRA owners who die after January 1st, 2023. So we're into that phase now. Under Secure 2.0, and this was the big change that happened, those IRAs, they are allowed to name charitable organizations to be the remainder beneficiary after the special needs individual. And that does not affect this lifetime stretch option for the disabled individual. And I say all of that particularly for those who worked with IRAs in the past and were aware of these rather stringent rules that if it turned out that a charity or a non-person was named as a remainder beneficiary, it would shorten the stretch options. It would really reduce what could be done to allow the required minimum distributions to stretch out over time. So this is an exciting change, and it really makes sense. For so many people, they really do want at least some portion of what's left after a special needs child passes away to go to ministries and to programs and charities who, played a big part in that child's life or serve other individuals with similar needs and do wonderful things in our society. So wanted to point out those rather exciting changes and make sure you were aware. Now, sole benefit trusts, we'll talk about those here for a minute, and then I have a few more slides toward the end, so we'll see them pop up again. but they're just a really unique creation. They are almost a blend between first and third party trust, but they fall under the official category of third party trust. They are used when the individual who's setting it up, and let's say it's the parent, that parent himself or herself needs Medicaid benefits themselves. They need to go into a long term care facility, for example. In general, Medicaid views that program as being designed for the quote unquote elderly and the disabled. And so they have some special rules as to transfers between those groups because they know that they're there to cover both. So this idea of a sole benefit trust is the idea that if a parent who needs to go into long-term care wants to preserve their assets for a special needs child, those assets can be transferred to a sole benefit trust, and that is not subject to the normal 5-year look back period for a gift. It is a gift, but there's no penalty for having made that gift as long as you do it in this special way. So not only are you then making that parent eligible to have Medicaid step in and cover the shortfall on their costs of their nursing home, but you are also preserving those assets that would otherwise have to be spent down for the benefit of a person with special needs, and you're not disrupting their benefits either. In, I believe, most states, that sole benefit trust can also name remainder beneficiaries because again, it's a third party trust. So it is not in most states subject to Medicaid estate recovery when that special needs beneficiary dies. So this is a very good tool. And a lot of parents worry about, well, what happens, I'll get all my planning done for my special needs child, but what happens if something happens to my health? What if I get dementia someday and I can't be at home? There's a lot of, planning around that. Where is the child going to live and the other issues? But on the financial end, this is a great tool for preserving assets in that circumstance. Next slide gives you just a planning tip on this, and that is, it is not limited to a parent. We think of it generally with parents, but any person who is going into long-term care and wants to preserve their assets technically could put those assets in a sole benefit trust for a disabled person. It doesn't have to be a relative at all. If you have an affinity for a friend or a nephew or a somebody, that's fine. It's not as common for that to happen, but it is perfectly legal. Where I do see it come up with a little more frequency is where a grandparent is going into long-term care and the family is trying to figure out, well, what should we do with the assets? Do we just have to spend them all down? I had a situation years ago where the grandparent had just one grandchild, and that grandchild was an adult and was physically fine overall, but was blind. So cognitively fine, I should say, but physically blind. And so qualified as a disabled individual. And we transferred the assets to that sole benefit trust for the blind grandchild. And the child was in favor of all of this. And we were able to preserve those assets for the long term for that granddaughter. So just an example to get an idea of how that kind of thing can work. Now, one of the issues that we run into with this is that if the grandparent has dementia at that point, they may not be able to sign a trust like that. And so that's where one of those myths that I mentioned comes into play. It's good to be careful to have a very well-drafted power of attorney that would authorize your agent to create different trusts on your behalf in case they would be useful in the future. So if it authorizes the agent to create and fund a sole benefit trust or a qualified income trust or a third-party special needs trust, it's best to have that language spelled out in the power of attorney. Those in general under the Uniform Power of Attorney Act are what are called hot powers, the power to create a trust or to fund a trust or to make gifts. And unless they're spelled out in the power of attorney, the Uniform Power of Attorney Act, which has been adopted in most states, will not let an agent do those sorts of things. And so you want to have a specially crafted power of attorney. Okay, now a few other requirements then about sole benefit trust to keep in mind. The person who creates it can be any age. However, the person that it's created for must be under age 65. So if we have a 95-year-old with a 75-year-old child with special needs, that's not going to be a candidate for a sole benefit trust simply because that beneficiary is too old. There's an age requirement, an age restriction on that. It also must be irrevocable, and there's special language. I'll point out that last sentence on the slide. It must say that it should be expended for the benefit of the beneficiary over the beneficiary's life expectancy on an actuarially sound basis. Well, that has not been tested to the truest extent. In other words, no state thus far has said you must distribute according to, for example, a life expectancy table like required minimum distributions from IRAs are handled. It is simply a nod that it should be used through the lifetime of the beneficiary. So, but in order to qualify as this type of trust, it must have that language, which is a little bit different than we see and use in the wholly discretionary trust and the D4A trust. In those trusts, we just simply say it's solely at the discretion of the trustee with no actuarially sound language. Now, a few slides on ABLE accounts. So just a reminder, an ABLE account is not a trust. It gets confused with trusts a lot. It is not a trust. It's just an account, and it's kind of like the college education accounts, the 529 college plans. And the reason for that is that it is a 529 plan. It's just a 529A instead of a 529C. So that is all IRS language. And what's been really interesting is to see the evolution of ABLE accounts. The chatter about it started, and the proposal started many years ago, probably 20, 25 years ago. It took a long time to get traction, but ultimately passed in a form that has helped a lot of people. So what are the regulations? Here again, I want to point out some new and upcoming things about ABLE accounts. Right now, you must have had your disability prior to age 26 in order to be eligible to have an ABLE account at all. However, unless Congress does something to actually change the law as it is written now says that effective next January 1st, 2026, if you had your disability prior to age 46, you are also then eligible to set up an ABLE account. You don't have to be those ages to create the account or anything like that. You could be, 85 and open up an ABLE account. If you had proof of some sort, some kind of evidence that you had your disability prior to the age, depending on when this is established, then you're allowed to have an ABLE account. In 2025, this year, the annual contribution limit is $19,000, period. That there is a little bit of an extra bump up if the beneficiary works, and there's language about that with all of the ABLE programs that you could find out about. There is a little bit of a bump up in certain states. You'll see Alaska and Hawaii have a couple of little bump ups on that. But in general, $19,000 is what can be contributed. And the thing I want to point out about that is that a lot of people are aware of this gifting rule. This is the annual exclusion for federal gift and estate tax purposes. And normally in that rule, anybody can contribute $19,000 to anybody else and it's disregarded. Here, the ABLE account can only receive $19,000. They can't receive $19,000 from mom and 19 from dad and 19 from grandma. It's only one $19,000 amount overall total in a given year. A couple of other rules about ABLE accounts. The contributions themselves are not tax deductible for federal income tax purposes, although they do qualify for the annual gift tax exemption or exclusion if we have a family where they might be taxable for federal estate tax purposes. Just a note about that. This year, the federal estate tax exemption is almost $14 million, $13,990,000 per person. That means if you die with less than that amount, you're not subject to federal estate taxes. And for the vast majority of Americans, that is the case. So we don't have too much worry about that in general right now. Also, an ABLE account can be established by a variety of people. It doesn't have to be created by the beneficiary, although they can if they're able, but a parent can do that for them, a guardian, an agent under power of attorney. If that person's able to sign a simple power of attorney, all of those individuals can create them. In addition, a disabled person can only have one ABLE account. You might say, well, this state's ABLE program, it has all these little bells and whistles. Let's set up one here and let's set up one there, kind of like 529s. You can have them in multiple states. No, that is not the case with ABLE. You can only have one account, and you pick the state that you do it in. Ohio has a lot of them because we were the first state to authorize them. We came out of the gates long before any second states, or any subsequent states, excuse me, started to create them. So we have quite a few. The contribution overall contribution limit is the same contribution as limit that state has for 529 accounts in general. Now that would take a long time to reach because of the limits on how much you can contribute to it in a given year, but eventually I'm sure we will see some accounts reach those points, and then you can't continue to contribute. If excess contributions are made, they must be returned to the person that put those monies in. Otherwise, there's a penalty. So there's a cost to it, 6% penalty. So if mom and dad put in $19,000, and lo and behold, grandma and grandpa forgot about that or didn't know about it, and they somehow made a deposit of $5,000, well, we got to get that $5,000 back out to avoid a penalty. ABLE account earnings are tax-free. That's kind of similar to the 529 college accounts. If they are used for qualifying expenses, we'll look at those in just a moment. And then, well, that's my next point here. Item number 10, qualified disability expenses are set forth in the POMs. And I have a slide down a few more that outline some of those, but you can see those also on the websites for the various ABLE programs. Few more regulations. There's a stipulation that if an account exceeds $100,000, then SSI is suspended. Well, it's going to be a while even before any of these accounts probably reach that because of the contribution limits. But someday, some accounts probably will. And it makes sense then that a needs-based benefit like SSI would be suspended until, that was brought back down to a lower level. There is a payback requirement for stable or ABLE accounts. I say stable because that's what we call them in Ohio. There is a payback requirement, but interestingly, I'm on a variety of listservs. There is a trend for various various states who are essentially waiving the payback requirement, and they're allowing the remainder in an ABLE account to go to the beneficiary's probate estate. I believe there are a few that are allowing a beneficiary or beneficiaries to be named. That's the minority so far. So this is something to just kind of keep an eye on, see what your state's doing. I believe I counted 17 states now that, at least ones that I could track down, that are not imposing a mandatory payback to that state for Medicaid purposes. It may end up changing though over time because the regulation is federal. It was a congressional act that brought about the stable account or the ABLE accounts. And at some point, they may step in and say, no, states, you're not allowed to deviate from that. There must remain a payback requirement. So we'll see how that evolves over time. The general idea, though, that I will say about both ABLE accounts and the D4A self-settled special needs trust is that you should aim to use them through the beneficiary's life. They're not really designed to be heavy-duty investment tools to pass on to the next generation. They're really designed to be safety nets for a special needs person. The other public benefits have limits to them, and it's very nice to have a safety net to draw from for other supplemental needs that arise over time, or to make that person's life more meaningful, better quality of life and so forth. Maybe offering the money or having the monies then to travel or have special equipment or other goods and services. Next slide then gives us a whole laundry list of various types of things that an ABLE account can pay for, and they are very broad. I think that most attorneys feel that if you can in some way justify that it's for the benefit of this person, then it's going to be allowable. The one additional thing I will mention about ABLE is that there is a strategic use of ABLE accounts when we go back to what I started talking about toward the beginning with SSI, and that is that shelter cost idea. If anybody other than the person, the beneficiary, pays for shelter costs, SSI can be reduced. An exception to that is an ABLE account. So if a parent wants to help a child pay for rent because the rent is more than what they can afford with their SSI, they can put the money into an ABLE account, the parent can. The ABLE account can then turn around and pay the additional rent cost, and that does not cause a deduction. It's just a special, unique exception with ABLE accounts. So there's some strategic uses for ABLE account in that context. All right, so a few Medicaid gifting rules. Main thing I'll point out on the next slide is please see that emphasis on the word only. The gifting rule of $19,000 is only a tax rule. It is not a Medicaid rule. If you give somebody $500 and turn around and want to apply for Medicaid, if you did that in the last 5 years, that can be a penalty. That will cause a penalty for your eligibility. The two exceptions are if you put those monies or that make that gift to a sole benefit trust or a special needs person, or there's a special exception for a caretaker child with a house. And that rule briefly is that if a child, has to literally be a child, lives with you for at least 2 years prior to you going into long-term care, during the Medicaid process, you can request that the home be transferred to the child, because had that child not lived with you, you would have had to go on into nursing home care earlier. There's also a parallel exception for a sibling, but those are just very rare, unique exceptions that you'll want to talk to counsel about if any of those would apply. Now, another type of trust is a pooled trust. I touched on this at the very beginning because it is a type of a self-settled trust, although there is a version of a pooled trust that can be for third parties. Pooled trusts are run by nonprofits who pair with financial institutions, and they're useful in various Medicaid contexts, sometimes because the beneficiary is over 65, and so they're not eligible to have a D4A or a sole benefit trust. This is on a state-by-state basis. There's about 18 states that allow that. The others have rules against an individual being over 65 even for a pooled trust. You have to see what your state provides, and local counsel can help you with that. But it can also be a tool for preserving assets for the individual who's in a long-term care facility to supplement their costs of care. And the next slide talks a little bit about that. What can those things be used for? One thing I will commonly use the pooled trust for is to pay the differential between a private room rate and a semi-private room rate. An individual may want to be in a private room without roommates, for various reasons. Medicaid won't pay that full freight. They'll only pay the semi-private room rate. So we can put monies in a pooled trust to help cover that difference. And there's some other examples on that slide of a number of things that a pooled trust can be used for. Next slide then goes back to the concept of sole benefit trust, here focusing on, for example, an elder, a parent or a grandparent that's going into long-term care. And I've really kind of already emphasized this, but the issue is that we may need to have a power of attorney that has the language allowing the creation of a sole benefit trust, because if we don't, and the person that would be contributing the monies is incompetent, this option of preserving assets in the sole benefit trust is just wiped away. We can't do it because we don't have anybody with the power to do it. In addition, a sole benefit trust is one of the few types of trusts, for those tax geeks out there, that qualifies as a disability trust. And I include this next slide because it gives you a little flavor of some exemptions or deductions that can be made when income tax season rolls around with special different types of trusts. So we won't need to dwell on it here today, but it's there if you're curious about extra income tax deductions based on a certain type of trust that might be used. Next slide again talks about the QITs, or qualifying income trusts. These fall into that category of self-settled trusts. And the main takeaway about qualified income trust or qualifying income trusts, sometimes called Miller trusts, is that these are somewhat state specific in the fact that states that have adopted rules about Social Security eligibility that are called 1634 states, that's a term of art, they require a trust of this nature if an individual has income that exceeds a certain threshold. That threshold changes every year. This year, it happens to be $2,901. So if I earn more than $2,901 a month on my Social Security, and I'm going into long-term care, I have to set up a QIT to receive at least some of my income and then turn around and pay that money from the QIT to the nursing home for my cost of care. I'm simplifying that a little bit, but that's a concept. And it's really just moving it from one place to another. It's not preserving the asset. It's just then making it possible for me to reach the income threshold and qualify for the Medicaid benefit. I point it out because if you have to go down that path, it can be very confusing, and it's good to just have a little base knowledge about what is this thing and how does it work or why is it necessary. No reason to set one of these up ahead of time like you would a special needs trust for a special needs child. This is only used when an individual has to go into long-term care and meet that income threshold. Okay, so I know I've gone long here a little bit on time. As a summary, hopefully you have gleaned that there is a reason to look at special planning for individuals who have special needs and individuals who would benefit by these various programs that all of us have paid into for the purpose of having extra societal supports. We don't want somebody to fall through the cracks and not get what they need when particularly they can't, so to speak, fend for themselves and be able to, cover their own support in that arena. I will mention here at the end, there's an additional slide about the Special Needs Alliance that I alluded to back at the very beginning. I think for this group, this is particularly useful because this organization is a national organization. It's not specific to the state that I'm in. I believe there are attorneys identified for most states. And so if you're not sure, or if your particular attorney that you work with isn't quite sure about special needs planning and wants to collaborate with someone who does a lot of that, that's a good resource. Plus, in addition to that, there's just lots of good articles, handbooks, resources, and we all know how beneficial that can be, particularly when we have a pressing issue on our mind that we're just trying to, Google that answer for. You can fall into some rabbit trails that might not have accurate information, and here's a source that can lead you to information that's current and accurate. I know that Lyle may have some additional comments here at the end, so I'll turn it back over to you, Lyle.
Thank you. Thank you, Jennifer. We have learned so much along the way. Very grateful for your teaching. Again, just want to highlight this webinar is provided by Anabaptist Disabilities Network. Would invite you to visit our website at anabaptistdisabilitiesnetwork.org. You'll find a lot of resources there, including recordings of this and other webinars that we have offered over time. A highlight of our recent offerings is the Believing and Belonging, an accessible Anabaptist membership curriculum. It's a series of lessons that are designed for those with intellectual disabilities who are thinking about church membership. And so it has Bible stories told at a third grade reading level. There's reflection and response activities, including some sessions that specifically talk about baptism and church membership in an Anabaptist perspective. So if you have questions about that, if you would like to contribute to the ministry of Anabaptist Disabilities Network, you can contact us at giving@anabaptistdisabilitiesnetwork.org. So thank you.